Floof. You've got your own channel, haven't you? And people can see you on Black Belt Floof, can't they? Welcome back to the channel and thank you for watching. This is a new surrounding for this video. It's not a sponsored video for those keyboard warriors among you, but this is a Kawai GX2 grand piano, which I love to play when I get time. I've played piano since I was about 7 years old. So many people have asked me to explain how a trial works and how evidence in chief works as against cross-examination and the purpose for each. And there is also what we call re-examination or redirect, as it's known in the United States. Redirect being, or re-examination being, responding to questions that arise from cross-examination. So I thought I would explain all of those to you very briefly in this video. So there are essentially three types of examination in court. There is chief examination, which is when you get your own witness as the barrister or the attorney or the lawyer, you get your own witness to give their evidence. And then there is cross-examination. That's when the opponent's lawyer is going to test your client or your witness's evidence and put their case to your witness to try to say that they are mistaken, wrong, misremembered something, or simply just put their case to them or test the evidence. And then finally, which is fairly rare, there is re-examination or redirect, which is addressing things that came up during cross-examination. And that is once again by the attorney or the lawyer or the barrister for the client or the witness for whom they are giving evidence. So dealing with those in order, chief examination must not be leading the witness in the evidence that they give. So all of the questions must be open questions. And when we teach advocacy and oral skills, we say that this must be an open style question to ensure that you are not suggesting the answer to your witness. And witness, of course, includes your client. So generally speaking, these questions, who, what, where, when, why, how, describe, explain, these kind of questions are going to be open. You may have heard a lot of what, if anything, did you notice? That's because if I were to say, did you notice anything strange about this individual? That's kind of a leading question because it suggests that you saw something strange about this individual, which might be noticeable, which might be valuable in evidence. Whereas if I say, what, if anything, did you notice? Generally speaking, that makes it an open question. But you may have heard in recent televised trials that the question, what, if anything, is not a get out of jail free card for examination in chief. Ideally, you should have a perfectly open question, not just what, if anything, did you notice that was very strange about this guy's face that made him stand out to somebody and so on. Obviously, that's a leading question. You can't just say what, if anything, and then cover all kinds of leading avenues in these type of questions. So the easiest way to describe how you would do examination in chief is if you were talking to a friend about what they were doing on a given day, at a given time, a given place, and so on. So if I were to say, ask your friend what they were doing yesterday at 9 a.m., what would you say? Well, you would say, what were you doing yesterday at 9 a.m.? It sounds obvious, right? But that is exactly how it should be done. If you were to just say, what were you doing yesterday? You will no doubt get a long-winded answer, all from the beginning of the day, from the moment they woke up. Well, I got up, I brushed my teeth, I went to get some breakfast, and then I realized I'd lost a sock, and so on and so on and so on and so on and so on. They would go through the whole day, not really getting to the point. If you were interested in what they did at, say, 11:30 that morning, and then let's say it was really important that they were at that place at 11:30 because they were delayed for some other reason, then you need to know why they were there at 11:30 or why they got up at 11:30. So you might then say, what time did you get up yesterday? And they might say, I got up at 11:30. Then you might say, well, what time do you normally get up? They might say, well, I'm normally up early. You'd say, what time is early? They might say, around 7 a.m. Then you say, well, if you normally get up at 7 a.m., why is it that you got up at 11:30? Then they might say, that's because I was up late the previous evening. And then you might say, why were you up late the previous evening? And so on and so on. So you get to the details without suggesting the answer, just by asking a very open, a very broad question. And you can probably see the Black Belt Floof over here, who has her own channel, by the way. So feel free to go and find Black Belt Floof on her own channel. So assuming you've now got all of your evidence out of your client or your witness using open questions, not suggesting the answer, not leading the witness, then it is your opponent's turn, your opponent lawyer's turn, your learned friend, as we say, to cross-examine your witness, your client. And what they are doing is trying to find inconsistencies in the evidence, or, as the case may be, simply putting their case to your witness or your client because they want to say that they are wrong. And this is where there's an important rule that comes into play, which is a fairly international rule. It's not just limited to England and Wales, where I practice as a barrister. It is fairly international. That is, if you want to say that a witness is wrong, mistaken, misremembered, lying, deceitful, or any of those kind of things on any varying scales of dishonesty or just mistakenness, then you have to put that to the witness. So if you want to say to a judge or a jury, this witness was wrong about that, you must put that to the witness to give them an opportunity to respond to it. Otherwise, you cannot make that statement because it would be against your ethical code of conduct in pretty much any jurisdiction, I would imagine. And more generally, there are tactics to undermine credibility of a witness. There are tactics to just confuse matters, to make it less likely that the witness was sure about what they saw. The classic example that I use when I teach these skills is to say that a witness is not 100% sure that this is the person they saw at that time and place or doing the crime or whatever it was. And to do that, you can use a very different tactic to evidence in chief. You use closed questions, so you do not use who, what, where, when, why, how, describe. You don't use all of those words. You use very closed questions and normally tag it with a, that's right, isn't it? Or, right, yes, you would agree with me, and you want a closed response. And so using these closed responses, you can build up to a conclusion. Now, we always say you want to start, in your mind at least, with the conclusion in mind. So you start with the conclusion, and then you find questions that will lead up logically to your conclusion, ideally that your witness is going to agree with in the build-up. They won't agree with your conclusion, because if you say to a witness, you're wrong about that, aren't you? They're going to say, no, I'm not wrong about that, normally. But if they agree with your questions in the build-up, this was this, wasn't it? Yes. This was this, wasn't it? Yes. This was this, wasn't it? Yes. And therefore, this is true. And they say, no, that's not true. Then the build-up is logical to the conclusion, but then it doesn't matter if they agree with the conclusion or not. And the classic example that I use, as I said, is being mistaken as to who they saw, whether they can be 100% sure as to the identity of the person they saw. So in this example, we often say, it was late at night, wasn't it? Yes. It was dark, therefore. Yes. But it was still a busy street, wasn't it? Yes. There were lots of vehicles passing by in front of your eyes. Well, yes. It was also raining that evening. Yes. That affected visibility somewhat. Yes. You normally wear glasses. Yes. And maybe they didn't wear glasses on that evening, or maybe the rain was on their glasses, or any number of different reasons that you can obscure the certainty with which they can say it was this person at that place at that time. And with all those questions answered in the affirmative, you can then put your conclusion, which is, taking all those together, you cannot be 100% certain that you saw this person at that time. Isn't that right? Now, of course, they will normally say, yes, I can be sure. Unless they are just a passerby and they don't really care and they say, well, you know, now you put it like that, maybe I'm not sure. But if it was the complainant in a case, otherwise known as the victim when the perpetrator is confirmed, or someone else who is genuinely making a claim and they desperately want to confirm this evidence, they will usually say, yes, I am sure. They will usually disagree with you. But at that point, it doesn't matter, because if your logical conclusion to all of the build-up is they cannot be sure, then it doesn't matter whether they agree with you or not. The inference drawn and the conclusion drawn by anyone listening, be it the judge or the jury, is that they cannot be sure that they saw this person. That is the objective of cross-examination. And then re-examination is a little bit like chief examination, however, only arising out of matters from cross-examination. So if there's a matter put in cross-examination about something with which you haven't examined your client in the first instance, you can then deal with that in re-examination or redirect and say, just to be clear, Mr. X, why was it you did this? Or why was it you were at this location? Or for how long did you do this? Or to whom did you say that? Or whatever it might be. And it gives your witness or your client the opportunity to respond to that particular allegation that came out of cross-examination. And in the broadest of sense, that is how evidence works in a trial. In chief, in cross, and redirect or re-examination. I hope you found that interesting. If you did, let me know by liking the video and subscribing and hitting the bell icon. And I would love to talk to you more about evidence and trials and how to conduct trials and how to be a lawyer generally. If you like those, please subscribe and I'll see you next time.